This is the CrowdCrux Crowdfunding Podcast with Sal Brigman, where we cover everything you need to know to launch a successful crowdfunding campaign. We speak with proven entrepreneurs who've raised money from the crowd and want to teach you how to do the same. Stay tuned because we're about to reveal how to launch your dream project. With your host, Sal Brigman.
Before we get started with this podcast episode, I want to take a second to introduce you to my friends at Fulfillrite. If you need help shipping out your Kickstarter or Indiegogo perks or rewards, Fulfillrite is the absolute best company for you. I've been working with them for a while and I can vouch for their services. They make it dead simple and take all of the headache out of shipping out all of those boxes, all of those orders to your backers and your customers. If you want to check them out, go to fulfillrite.com at fulfillrite.com. Hey, welcome back to the Crowdfunding Demystified Podcast. My name is Salvador Brigman, and today we are getting into how you can use equity crowdfunding for your business as an entrepreneur, as an inventor, as someone who's creating a new company. How can you use equity crowdfunding to raise money for your business and also get access to a lot of early adopters? You know, these people that invest in your product, they aren't just necessarily putting financial, investments into it. They're also becoming evangelists for your brand. And that's what I think is really cool about equity crowdfunding. It's really just Kickstarter for equity. You know, you think of Kickstarter, you're giving away perks and rewards. In addition, you're getting pre-orders, early adopter customers. With equity crowdfunding, you're not only making an offer online, creating a pitch video, doing a campaign text, all that kind of stuff, doing a marketing strategy, but instead, the people that actually back your project are investors in your business. It's literally Kickstarter for equity. So they're actually getting a very small percentage share ownership in your company and can experience some of the financial returns should you create down the road, doing an IPO or selling your business. So this is something that's kind of new, but it's also grown a lot, man. Like, WeFunder recently hit the $100 million mark. It's insane just the pickup that this industry has seen. And I think it's time that we start to talk a little bit about this. So that's why I want to bring on today's podcast episode, an individual out there who is on the front lines when it comes to the legal side of equity crowdfunding, which I think kind of gets people a little bit confused and also a little bit fearful, because anytime you're offering securities or offering these shares to the public, that's something you have to be aware of. Or what are the legal ramifications? What are the things you need to be checking the boxes for and be aware of going into one of these campaigns? So I brought on a lawyer who has a little bit of knowledge here when it comes to that, and also can tell us a little bit about different regulations like Regulation D, Regulation Crowdfunding, Regulation A+, and in addition, can get really into the costs related to an equity crowdfunding campaign. I think that's kind of like always hush-hush. Lawyers don't want to talk about their fees. No one wants to talk about their fees and what they're going to charge, but this lawyer in particular was very upfront, was very giving, and was very transparent about what it's going to cost you to run a equity crowdfunding campaign. This is incredibly valuable information and knowledge. Think of this as a free consulting session, honestly. And you know how much lawyers charge. So you're getting access to a really intensive, bite-sized version of how to do one of these campaigns. If you want sort of the full-fledged roadmap, if you will, for running an equity crowdfunding campaign, I got a great book out there on Audible called Equity Crowdfunding Explained, which you can check out at crowdcrux.com/equity audio. That is crowdcrux.com/equity audio. And if you can't access that link, crowdcrux.com/equity audio, you can also just search Equity Crowdfunding Explained on Amazon or on Audible, and you will come across my book by Salvador Brigman. Hope that helps you out, and I hope you take a lot out of today's episode. We're focusing on everything when it comes to this new fundraising medium, how you can do like a mini IPO kind of, and abide by all the right regulations, and you can raise hundreds of thousands of dollars for your company using crowdfunding. Hope you enjoyed it, and it's coming up right after this. Hey guys, welcome back to the Crowdfunding Demystified Podcast. We're lucky today to be talking to Tom Goldstein, who actually helped me back many years ago when I was just starting my blog, and I had taken an image off of Google Images, and that's something that's like a no-no, something you're not supposed to do. I got into a little bit of trouble around that, and he sort of helped navigate me through that, made sure I didn't get into any major legal hassles. So I've known Tom a while, way back when I went to college and DC Tech was just starting to become a thing. He's an excellent lawyer, and he's come on the podcast today to talk a little bit about equity crowdfunding and also, in general, starting a business, what you should know when it comes to the legal side of the business. Tom, welcome to the show.
Sal, thank you very much. Thank you for those kind words, and thank you for having me on. Just want to say I'm really impressed with the way you've grown your business over the years and all the issues you've taken on and the resources you're providing to the community. So it's a pleasure to be on your podcast.
Thank you. So equity crowdfunding was kind of one of those things that I felt like was such a really niche thing, but it seems like it's getting a lot of traction and even the attention of lawyers out there. How did you first come acquainted with that? When did that get on your radar?
Well, I've been following this really for a number of years. As you know, the equity crowdfunding as distinct from, say, the reward gift model of Kickstarter and Indiegogo. Equity crowdfunding goes back to the Jobs Act that was passed in 2012. Now, originally, the SEC was supposed to come up with regulations, that would make equity crowdfunding possible within, I think it was maybe a year and a half. But
of course, that didn't happen.
Of course, no. Shockingly, the government took a little bit longer than blew their deadline. So it didn't go into effect until 2016. Now, I think one of the things, so to answer your question, I've been following this and sort of watching this and waiting for this to develop, since it was passed. I think it's a great new tool for businesses that don't have the same, the kind of access to capital that, aren't
a large company, venture capital have, yeah.
Right, or don't have, a wealthy, a network of friends and family with, a lot of wealth. So it's a way for people to kind of, it democratizes access to capital.
I got to ask you, how is this different from things like, a Reg D offering or the way that, money was traditionally raised from angel investors?
Okay, that's a great question, Sal, and that's really the key thing. So under a Reg D offering, and there's a couple of different flavors of it, but basically a Reg D offering in general, you are limited to people that are accredited investors. And that means that people that have either a certain amount of net worth, and, I think it's, over $1 million excluding your primary residence, or make over more than $100,000 a year. And obviously that excludes a substantial number of people. So if you do a Reg D offering, and you also, you can't market it just, there are very specific rules about, how you offer it and under the circumstances you offer it.
The main thing being the people that you market it to. If you're doing a 506c raise, you can market it to people, but it's only if it's for accredited investors, basically.
Yes, and that's right. And so, it's not really a public offering. And, look, there's good reason behind this. I want to say that, the securities laws go back to the Great Depression era, and they were passed because in the immediate preceding period in the 1920s, which is really when you have the first real stock market boom, when, sort of middle-class people are playing the market and it sort of becomes a broad national phenomenon. And, in a lot of ways it was like today. I mean, people talked about General Motors then the way they might talk about Apple or Amazon or Facebook, if you'd only bought General Motors, 5 years ago, you'd be rich now,
Mm-hmm.
And so what happened was there were a lot of people out there who were doing fraudulent schemes. You've heard of Ponzi schemes, right? Well, there was actually a guy named Ponzi. That's, where the name comes from. And so basically what happened is there were a lot of people that were making outlandish promises of get rich quick. You can offer, saying, hey, buy this stock. This company is making all kinds of promises. And, many of them were cons or outright frauds. And then there were others that were probably well-intentioned, but, the people didn't know what they were doing. And so a lot of small investors, lost their shirts and, lost all their money. And so in the 1930s, Congress passed laws during the New Deal to basically put very strict limitations on under what circumstances you can offer stock or any securities, including debt, to the public. And the general rule is you have to do a registered offering through that's approved by the SEC. That's what an IPO is. And it's extremely expensive, and it has to be approved by the SEC. And
broker dealer has to get involved, right? Something like that.
That's right. So it's not a viable thing for a startup. So what you talked about, Reg D, is one of the exemptions, and it's one of the ways you can raise capital without doing a registered offering with the SEC. Mm-hmm. But as you noted, the limitation on a Reg D offering is that it's limited to people who are the so-called accredited investors.
Mm-hmm. So how's crowdfunding different? Like, how is regulation crowdfunding different, or some of these other ones like Regulation A+?
Okay, so let's talk about Regulation CF. That's the one. So under Regulation CF, you are not limited to accredited investors. Anybody can. You can sell to anybody, and anybody can purchase your securities. What you are limited, there are several limitations though. So under Reg D, you can raise. There's no limit to how much you can raise. Under Reg CF, you can raise a maximum of $1,070,000 in a 12-month period. Under Reg D, you don't need to do it through a broker dealer. Under Reg CF, you have to go through either a broker dealer or a so-called portal, basically a website, a portal that has been approved by the SEC and FINRA. And also with a Reg CF offering, individuals are limited to how much they can invest. And if they make under $100,000, they're limited. I think it's up to $2,000. And if they make over $100,000, I think it's 10% of their annual income, and that's across all the offerings they make, all the investments they make during a 1 year or a 12-month period.
And you guys have been handling these types of, offerings, you'd say, in your own Cogent law firm. Is that right?
Yes, we have. One of my colleagues, Maureen Murat, and I will say, by the way, that I am a generalist. I'm not a specialist in a securities attorney, but we have multiple lawyers with substantial, deep knowledge of the securities laws who specialize in, among other things, equity crowdfunding. So my colleague, Maureen Murat, she has advised 4 companies on equity crowdfunding raises, 2 of which have been successful in meeting their goals.
That's incredible. How do you have any idea how much they raised at all?
Yeah, I think one raised several $100,000. I think the other raised around $100,000. And by the way, I will say that you need a good lawyer to make sure that you're in compliance and you don't get in trouble and all the paperwork is okay. I will say, though, that having a good lawyer is necessary but not sufficient for having a successful raise. Marketing is obviously a very big part of this too. Mm-hmm. Ultimately it's the underlying business model, having a strong team and, a marketing budget, all of those things, are clearly important. But, you need a lawyer with experience in this who can help you get the legal side in order.
One of the things that I was sort of reading through was that under regulation crowdfunding, if you're doing some of the larger sizes, like 500K or more, you need financial statements reviewed by an accountant, or audited, reviewed financials are given. But like $107,000 or less, all you really need are financial statements and a tax return. Do you think if you're raising less than 100K, you also need a lawyer to look at these papers, or do you think there's any kind of boilerplate like content and stuff?
I think you should get a lawyer, even if you're doing a raise under 107,000. I mean, first of all, when you go and put together, say, an application, let's say, for example, Start Engine. What they do is you fill out an application, and Start Engine will then, and Start Engine, by the way, is one of the major crowdfunding. It's one of the big three major crowdfunding, equity crowdfunding portals. So if you do an application, they will use that to generate an offering circular that will then get filed with the SEC. And so, even if you're doing a raise under 107,000, there are issues like, okay, what type of entity do you have? Are you an LLC? Are you a C corporation? Have you been authorized? Is the entity authorized to do this raise? What type of shares are you issuing? Now, look, you could go online and try to figure a lot of this stuff out. But the thing is, if you get these things wrong, and,
it really messes you up.
Yeah. And it can be extremely costly and expensive to fix it later. Our standard, we generally charge a flat fee for preparing the paperwork and ensuring compliance with the Reg CF crowdfunding offering, and that includes reviewing the entity, helping, if necessary, forming the entity, reviewing, making sure the entity is authorized, the crowdfunding. The rates. We can do that. Our package starts as low as $3,000. And so, I think if you don't have $3,000 to spend on something like that, then I think, you may not be, you need to have some working capital to get a business launched. And as I said, there's all kinds of trouble you can run into if you don't do it right. The
other thing, just saying there really quickly, I think it's almost like you're paying for peace of mind, honestly.
Yes.
Because if you do it right, you might be doing it right, and also you might not have to pay that $3K, but also you don't know. It's kind of like having a small investment. You are able to have peace of mind and knowing that you're doing things by the book, and then you can just focus on marketing, because that's really where the gold is. I think that's where you're going to be successful or not. And you can just get out of the way some of these more necessary types of things. So you guys mainly do regulation CF. Do you do any kind of like Reg A plus stuff?
Oh yeah, absolutely. And I just want to add one point. So we had somebody come to us who basically did the application on their own, and then learned after the fact that they had not, one of the things that they had to do was they had to get a filing in the state they were located in. So there was a separate regulatory filing they needed to make in their state. And they actually had that state's attorney general's office come after them and say, hey, what's going on here? We see you're doing a public offering through this, this crowdfunding portal, but you never made the regulatory filing that's required with us. And, that's just one example of the kind of thing that, you wouldn't necessarily know if you're not a lawyer that specializes in this area.
Yeah, and also just knowing like the court cases or anything related to securities law is just difficult in general.
Yeah.
So
I'm sorry, what was your question again?
Before we get to that, so you mentioned one of the websites out there was Start Engine. Do you know of any of the other ones people can check out?
Yeah, I think Seed Engine. Let me give you a second.
I know Seed Invest is one of them.
Seed Invest. Seed Invest, and
I feel like,
and I think WeFunder. The big three are Start Engine, WeFunder, and Seed Invest. And I think they've got between them probably upwards of 50% of market share.
mm-hmm. Fun fact also, WeFunder recently hit 100 million that was invested on their platform. That is a milestone.
Wow. I think, let's see, the to date, I think the total commitment is around 262,000 with close to 300,000 investors and almost 1,900 crowdfunding campaigns. With the average raise, I think it's 235,000.
Mm-hmm. That's incredible, man.
Yeah, great. It's really great to see. And frankly, I think this is the tip of the iceberg. I think it's going to get much, much bigger. I mean, many small businesses and startups are not even aware of it at this point.
That's why I got the podcast. That's the whole goal here.
You're doing the Lord's work, Sal.
I don't know about that, but when it comes to a regulation crowdfunding campaign, it sounds like the everyday entrepreneur can get this done. $3,000 in legal expenses, you get the accounting done, you put together the marketing campaign. The actual cost for doing it is very similar almost to doing a Kickstarter or an Indiegogo.
Yeah, that's my sense. And from what I've been told and what in talking to folks, I think you generally need to budget about 10% for the amount of the raise that you're targeting for the marketing. And obviously that's not a hard and fast, but I think that's a good rule of thumb, sort of a good starting place.
Mm-hmm. Yeah, that's pretty well said. I had to interrupt this podcast episode because I want to introduce you to my friends at The Gadget Flow. Their product discovery platform reaches 22 million people per month. They've helped more than 5,000 crowdfunding campaigns thus far, and they have a social media following of more than 700,000 followers. If you want to gain access to their marketplace and list your own product, you can go to thegadgetflow.com/submit and list your project today. Regulation A+ is like this other big granddaddy in the space where, I mean, a lot in real estate crowdfunding, honestly, but also with, startups and entrepreneurs that are a little bit more mature stage. Is that something that you see people that are like, smaller businesses ever getting into, or is it just so costly, or can you just shed some light on that?
Sure, absolutely. And yes, I think one of your questions earlier, yes, we have represented, our lawyers have worked on, everything from, Reg CF, Reg D, Reg A+, all the way to IPOs and, major public offerings. So look, I think it depends on the business. If it's a business that is looking to raise, a couple of $100,000 to get working capital, maybe to get, let's say a restaurant off the ground. If it's a business that is sort of, it's a business that the owner is going to make enough money to support, make a living, but they're not looking to scale it, really do mass scale. They're probably not. They're not likely necessarily to get to the point where Reg A+ is going to be relevant. I mean, Reg A+, you can raise up to $50 million. And so but a Reg A+ offering, just for the legal work alone, you're talking about anywhere from, say, $75,000 to potentially a couple $100,000. Now, you might ask, why is that so expensive? Well, a Reg A+ offering, the way it's been described to me is it's sort of halfway between doing a private placement, which, is not, the SEC doesn't have any review of and doesn't have to approve at all. to doing a fully public registered offering like an IPO. Mm-hmm. So Reg A Plus is kind of about halfway. And so the SEC has to approve it, mm-hmm. and they're going to look at that with a lot of scrutiny. So, for example, you need to have at least 2 years of operating records. Mm-hmm. So, obviously, if you don't have 2 years of operating records, and, when you're starting a business at an early stage, you often,
it's more for a mature company, it sounds like.
Yeah, that's right. So, and there's a lot of back and forth between your lawyers and the regulators. Mm-hmm. And that's not something your lawyers only have so much control over that, because the SEC, ultimately it's what they care about, and whether they think it's something they're willing to approve. And so, your lawyers, if your lawyers get involved very early, they should help you plan for that and manage it so that the time you're ready to do a Reg A Plus, there'll be less back and forth. But
let me ask you a dumb question here. What's the difference between a private placement and a Regulation D offering?
There isn't any.
Okay.
Private placements are done under Regulation D.
Okay. And is that a subsection of the rule, or just kind of like vernacular for?
Vernacular. When people talk about doing a private placement, it's basically, a Reg A Plus is a public offering. It's made, so I should say the difference between a Reg D offering and a Reg A Plus offering is a Reg D is limited to accredited investors, and there's no limit to how much either an individual can invest or how much they can raise. Mm-hmm, mm-hmm. And so, you could have a venture fund put in, $100 million into it, or more.
Yeah. So that'd be like a Series A, Series B, Series C.
Exactly. That's right. A Reg A Plus offering is open to the public. It's not limited to accredited investors. And that's why the SEC looks at it with so much scrutiny. And it's also limited to up to 50 million.
Yeah, it's been used very successfully by some of the real estate crowdfunding platforms out there like Fundrise. So one of the questions I had for you here also was, we talked a little bit the costs of doing a regulation crowdfunding campaign, and the benefit there being you can basically advertise this and market this to everyone. When it comes to a Regulation D campaign, are the costs similar? Are they more? Is it more difficult? What are your thoughts on that?
Reg D is probably a little bit more. It really depends on a couple of factors. So in a Reg D offering, you typically do a private placement memoranda. And, this is something where you describe the business and you disclose some risks. And, it's to protect you so that later your investors can't come back and say, hey, you misrepresented what you were doing. You said you were going to do X, but you didn't. You had something else completely in mind, or you represented that you had these advisors, but, they weren't actually advising you, or, you did this market study. So what a lot of it consists of a business plan. So if you have a very well-developed, polished business plan, then turning that into a private placement memoranda might be something that can be done fairly easily. So on the other hand, if you're starting from scratch or have something that's very rough, it might take more time. So, I'd say, under the right circumstances, maybe, 5,000 or 6,000, but, you may very well end up spending 10, 15 or 20,000. And, that's also going to depend, there's also regulatory filings you have to make at the state level. And that's going to depend on how many investors and where those investors are coming from. So those are some of the factors. So I would say it's going to be more expensive typically than Reg CF, but vastly less costly than a typical Reg A Plus.
Mm-hmm, mm-hmm. Okay. So I have just a few more questions when it comes to starting a general business. But before we get into that, do you have any other things you'd like to leave with the audience when it comes to regulation crowdfunding?
Yes, and so I guess a couple of things, and these may not be completely legal points, but just um, the kind of things that make a equity crowdfunding campaign successful. Um, First of all, if you have one or two investors, or for that matter, it could be any number of investors, but if you have people ready to commit, say, ideally up to $50,000 on day one, that's really, really helpful, because once you hit a certain threshold, the crowdfunding sites, the portals, they want you to be successful because the more money you raise, the bigger their fees are, because they're taking a percentage typically. So if in some cases, I think start engine it's around 45 or 50,000. Once you hit that amount, they will then blast out to their huge, database of investors, and promote it. So, if you have what I think equity crowdfunding under Reg CF is really great for is if you have, say, one or more individuals ready to write you collectively checks for, say, 50,000, and you want to raise around 200, but you don't know where to find the rest of the 150. Have those, do an equity crowdfunding campaign, have those individuals write the checks, or excuse me, instead of writing the checks, have them make the investment on day one. That way, and by the way, once you've gone over 10,000, typically you can take the money out, and you can then you'll have so you can the 50,000 you can take it out right away, spend it on marketing, and if everything else is good and you've got a good business plan, you can take it out. That you can use hopefully to get yourself up to say 200,000 or perhaps more. So that's
kind of like prime the pump. Yeah, prime the pump with your own outreach to investors. And in that way, you kind of jumpstart this whole fundraising process on a site like Start Engine, Seed Invest, or WeFunder.
That's right.
I just had like a few more questions for you here when it comes to entrepreneurs in general. I think that we are really focused types in that a lot of us are creative. Some of us are more focused on product and technology. I'm more into sales and marketing, but we rarely think about the legal side of a business. What would you say are one or two major mistakes that you see commonly entrepreneurs making that they should remedy, or they should at least be aware of?
Okay, I'll give you a couple of examples. One is if you have more than one founder, not having a good founding document. So if you're an LLC, not having an operating agreement. If you're a C corporation, not having a shareholder agreement, because, people who start a business together are sort of by definition, they're people that have a good relationship. They may be close friends, they may be even family members, but they trust each other. Now, the problem is not that people turn out to be untrustworthy. The problem is circumstances change. So you and I might start a business and we've sort of carved out how much time we're going to put in and, the different roles we're going to play and how much, and we have all this in our heads and we've discussed and we've talked about it. But, what happens if, say, I'm offered a really sweet job, salary job, and, that I can't turn down. And so, so suddenly I'm not available to do all the stuff I said. Well, how do we resolve that? Or, somebody, or I have, I get divorced and, what's the impact of that? Does, my ex-wife now own, half of my interest and is she now your business partner? Or, what if, you've got to move across the country to take care of a sick relative and you can't put the time into it. So lots of life happens and things come up and people of good faith, who, want to do the right thing will suddenly find some circumstance that, that was never discussed. And suddenly it's not obvious what the fair approach is. Having a good founders agreement in place, again, whether it's an operating agreement or shareholder agreement, means, for one, it forces you to think through all those issues up front. And so then, it's like, okay, so we talked about this, and then if this happens, then we agree we're going to deal with it this way. So, that makes, and then there are occasions, unfortunately, where people don't act in good faith, or they just, I know of people that, had a great business relationship, and then, it just turns sour, and, trying to extricate yourself from something like that without an agreement can be very frustrating. So that's
plan for the worst. Plan for.
Yes. And the good thing is it doesn't cost very much to have a good founders agreement. I mean, it's really make anywhere from like one, maybe as little as $1,000, $1,250. Maybe if it's a really complicated agreement, it might be $3,000 or $4,000. But, again, it's not the sort of thing that's going to break the bank, and it can save you so much heartache. And frankly, if you wind up litigating your dispute because you didn't have a founders agreement several years later, that can cost you tens of thousands of dollars. So I'm a big fan of, if there's something that doesn't cost very much and can significantly reduce your risk, those are the priorities. And then I'll mention one other area, which is intellectual property protection. And you have some familiarity with that yourself.
Yeah.
So
it was not fun.
Yeah. So in particular, I would say if you're building a brand, and that's whether it's your company name, product name, a logo, a slogan, make sure that you can protect it, and that it isn't already owned, that, logo, product name, etc., isn't already owned by somebody else. Nothing worse than spending a year, 2 years building a nice brand and getting some real traction, and then getting a cease and desist letter saying, hey, you got to, stop using this name immediately, or, we're going to come after you. You don't want that to happen. And a good intellectual property lawyer can do that, can advise you on that for, again, probably under $1,000,
Yeah. One of the final question I had for you here is a little bit, I think, of a gray area. A lot of the times we think that when you have a contract or when you have a legal agreement, that it's almost like ironclad because it's legal. But at the same time, so many business dealings nowadays are online and international. What are your thoughts on the enforceability of contracts in an international context?
Well, that's a great question. And it can be potentially, one of the issues is if you're dealing with, if the other party is in another country, now, what law governs the deal? Well, if the contract's written so that U.S. law governs, and, the case is heard in a U.S. Court, well, that's great. But, one issue is, let's say you win a judgment against them. How do you, you have to have, they have to have assets you can go after. And, enforcing a judgment against somebody who is in another jurisdiction can be, very tricky and lengthy and time consuming and particularly expensive. I will also say that one of the challenges of contracts is they are expensive to enforce. And a problem is, somebody, for example, you do work for somebody, they pay you half up front and half at the end. And then when the time comes, they say, I'm not going to pay you. And so you say, all right, I'm going to sue you. Well, what's very, what they may do then is they may, if you sue them, they may say, okay, all right, well, we'll offer him half of what we owe. And, your lawyer may say, I think you got to take that because, even, it's going to cost, even with a firm like ours where we can do things super efficiently and at below market rates, it's still going to cost money to litigate this case. And so, you might end up spending more money enforcing the contract. You might just be better off, accepting, 50 cents in the dollar or 60 cents in the dollar. And the way you get around that is having a provision in the contract that says that if there's litigation between the parties, the losing party has to pay the winning party's attorney's fees.
Is that usually enforced correctly? Like that usually is awarded?
It's at least partially awarded, I think, typically.
Okay.
I think, again, it sort of depends on the conduct of the parties, but let me put it this way. It gives you the threat of the possibility of the losing party having to pay the winning party's attorney's fees, that then goes into the calculus of how much risk. And so suddenly, the idea that you're going to offer 50 cents in the dollar or 60 cents in the dollar because the other side is not going to want to spend the money. Well, okay, now you're looking at potentially paying, if you lose the case, you got to pay your own legal fees. You may have to pay everything that you wrote in the contract. And, potentially, even if it's only partially what the other side's costs are, that gives you a lot more leverage in trying to
do this. Yeah. I think one of my biggest takeaways is that there's basically a difference between the way that the book version happens from a legal process or how we think about entrepreneurship or we think about, enforcing contracts versus kind of how it works on the ground and in the real world. And probably getting legal help is one of those things that kind of bridges the gap and makes you actually understand the implications that certain agreements have, or, all these different things that you just don't even think about. So I think it's kind of cool. We can end on that note because I think, you've shared a ton of great stuff in this interview and I want to be mindful of your time. And I think we're really lucky to also have you on and to share all these things about equity crowdfunding because it's a massive boom and so many new companies are using it. It's becoming a lot more easier now that lawyers know how to do these contracts quite simply. The costs go down. In general, I think it's going to be really great for the next coming years as well. So I just want to say thank you so much for coming on the show. And if anyone's interested in learning a bit more about what you do, where can they go and do that?
They can go. Our website is www.cogentlaw.co. COGENTLAW.co. They can email me at tgoldstein@cogentlaw.co, and that's TGOLDSTEIN. And they're welcome to call me at 202-669-4585. 202-669-4585. We do free consultations, and very happy to talk about advise whether it's on crowdfunding or on anything else. We're a full service law firm, and
I gotta say, man, too, just to add on to that, like it's so rare. I always come across service providers that are not willing to give people realistic ideas about like quotes and prices and all this stuff. And it's so refreshing to hear you bringing that to the audience. I think you guys are super transparent about that, and I appreciate that a lot. So thank you for coming on the show, and we'll have to have you back.
Hey, Sal, thank you so much. I really appreciate the opportunity to be on the show, and I enjoyed it. So, okay.
Let me tell you about our latest sponsor, SendPro Online by Pitney Bowes. Shipping can be complex. Things can get really confusing really fast. With SendPro Online, it's easy to save time and money no matter what you send, from letters and packages to overnights and flats. You can easily compare USPS, UPS, and FedEx in an all-in-one online tool. You can print shipping labels and stamps directly from your printer. You can even track all of your shipments and get email notifications when they've arrived. SendPro Online is only $14.99 a month, and listeners can get a free 30-day trial when you visit pb.com/crowdcrux. That's pb.com/crowdcrux. Experience the convenience of SendPro Online for yourself when you sign up for a free 30-day trial.
Thank you for listening to this episode of the Crowdfunding Demystified podcast. Today, you got some information when it comes to equity crowdfunding and how to raise money for a campaign, as well as some real-world costs for hiring a lawyer or hiring help when it comes to putting together this type of offering. It's not super expensive. You think about going out there and trying to get angel investors or trying to get venture capital. That's freaking expensive, man. And I think that this is a whole new way, a whole new medium, if you will, that you can actually connect with not only just backers and like people that are early adopters, but also investors in your company that could know even more investors. And you can use this sort of as a springboard, if you will, to raise even more capital. And I think it's just a very special time because the ability to reach out to a bunch of people that you don't know, that's really big. I mean, that's huge. That's basically you using the power of social media to power your fundraising efforts when that was really never before possible. These securities laws were put into place for a reason. And as the internet has started to grow and to expand, now there are new ways that you can actually raise funds, and the securities laws are starting to become accustomed to that. They started to mold and shift and change. We haven't even talked about like ICOs and like these other things, but just when it comes to equity crowdfunding, I hope you took out a lot from today's podcast episode. And also, if you want more of a deep dive, this is kind of like an introduction. If you want more of a deep dive when it comes to equity crowdfunding, you can pick up a copy of my book on Audible called Equity Crowdfunding Explained. Very intensive, very comprehensive step-by-step plan for raising money with an equity crowdfunding campaign. I also read that book myself. So if you're interested, you can check out at crowdcrux.com/equity-audio. That is crowdcrux.com/equity-audio, crowdcrux.com/equity-audio. And again, my website was having some difficulties last few days, had to get them fixed. So if for whatever reason my site isn't online, just go and type in Equity Crowdfunding Explained on Amazon or on Audible, and that will come up for you. Thank you for listening to this episode of the podcast. Go check out some of the other ones we got out there in the archives, and I will see you next time.